Today we're talking guns in Texas and unlawful carry laws. When can you get arrested just for having your gun? Now, before I get started, I know this is a political hot button issue, but I don't really have an opinion either way, and I've probably pissed off both sides by saying that. But I'm really just going to be talking about the nuts and bolts of defending a UCW case, an unlawful carrying of a weapon charge. And that can apply to a gun, an illegal knife, or a club. Now, none of this is legal advice, but if you would like to reach us, you can always give us a call or visit us at atx.legal. Fill out a contact form for a no-cost consultation. Now, the laws all change in 2021. You might have heard of permitless carry, and that's just what it sounds like. You do not need a permit to carry a gun in most cases in Texas, and that goes for concealed or open carry, either way. Now, there are obviously exceptions to that. Any airport, you can't have your gun there. Schools, correctional facilities, courts, all the places you might expect where you wouldn't be able to have a gun. And if you do carry your gun in one of those places, you might get charged with unlawful carry. In most cases, it's a misdemeanor, but it can be a felony if it's at a place that serves alcohol. And in addition to that, any private residence can ban guns. They can do that with signage, but they don't have to. They can simply ask you to leave if you have your gun, and you're required to do that. There's no requirement that any private facility allows you to have your gun at their private establishment. And the other big exception, and by far the most common way I see this charged, is you cannot have a firearm while committing another crime. And that crime can be any Class B misdemeanor or up. So think even a DWI or a minor drug charge. If you do have a gun with you, then that could be a separate charge, the unlawful carry of a weapon, and it'll be a Class A misdemeanor. And I don't want you to get confused here with felon in possession of a firearm. That's a completely separate charge. That's a felony. I'm not talking about that here. I'm talking about this other charge, which is in most cases a misdemeanor. So in practice, what this means is if a person is charged with something, let's just say a DWI, and they have a gun with them in the car, they come in with two separate charges. You would now have to post bond on both charges, and you would have to proceed on each charge separately. Now, if it does end up going to trial, the prosecutor could proceed on both of those charges at the same time, but in practice, a lot of these cases don't go to trial. In fact, in Travis County, it's very easy to have these charges dismissed, but there's a big catch. You just need to forfeit your weapon. So if it's a weapon you're very attached to, if that gun has sentimental value, the prosecutor is still going to require you to forfeit that weapon, and then they'll say, well, we'll dismiss the charges. Now, for my clients, I try to get them to view this in most cases as a fine. It doesn't stop you from going out and buying a new weapon, an identical weapon if you want. So you can consider the cost of that gun simply a fine that you had to pay to the government. Now, the current Travis County DA, Delia Garza, is very hell-bent on getting people to forfeit weapons. Even in charges that aren't related to the weapon, she's asking for the defendants to forfeit those guns as part of a plea deal. And in most cases, if it does smooth out that plea deal, I usually try to encourage my clients to go ahead and accept it. Again, try to view it as a fine rather than giving up that prized weapon. You can go out the next day and buy a replacement. But to give you a little idea about the county attorney's stance on guns, I have a case right now where the underlying crime has already been dismissed due to lack of evidence, but the county attorney is still not dismissing the unlawful carry charge. Now think about that. The unlawful carry charge is based on this other crime. Without that crime, the unlawful carry cannot even be a crime, and yet I'm having trouble getting the county attorney to dismiss. Why? I don't know. It's just an initiative of the office. I can't really explain it, but it is how they're treating weapons at the present time. Now, if for any reason we're not wanting to forfeit those weapons, sometimes it's because they're high value items, or for any reason, maybe there's sentimental value there, the person doesn't want to give up those guns. There are some defenses to unlawful carry, and the main one is the one that I just alluded to, and that is they have to prove both crimes. So they can't just show that you had the gun. If you had the gun, but then you get the DWI or whatever the other charge is dismissed, then the unlawful carry charge should go away as well. Now, by far, the second most common way people get an unlawful carry charge is at the airport. If you're going to the airport, don't take your gun, don't check your gun, just don't have it there. If you need it for some special reason, you're going on a hunting trip, just make sure that you follow the instructions of the airport. I would call ahead and let them know what's going on and get their step-by-step instructions on how not to get an unlawful carry charge at the airport. And if you do get a charge there, you're kind of dead in the water. If you were at the airport and you had the gun, there's usually ample evidence of that. So the prosecutor might not be as willing to drop that case. Just going to have to make that argument that it was an accident, you didn't mean to have that gun there. And in that case, the prosecutor might be a little bit lenient, and she's still going to ask for that forfeiture of the weapon. And that's all I have on unlawful carry of a weapon. Again, it's not legal advice. If you do need legal advice, if you've been charged, give us a call or visit us at atx.legal.